Welcome to the FloridaDefense.com podcast. With over 30 years of strong defense and over 30 years of even stronger results, with FloridaDefense.com, you'll never believe you can't win.
You are listening to the Bauer Crider Perry podcast. Bauer Crider Perry is criminal defense attorneys in Tampa, Florida. And we are speaking to Mike Kinney. Good morning, Mike.
Morning. How are you?
I'm doing well. Let's kind of jump in this morning. We are going to be talking about just the DUI process. You know, sometimes I would think, hey, can I just skip all these tests and give me the breathalyzer? They can't do that because you have to be arrested first.
Yes.
Okay.
Yes. So you can say I want to skip the field sobriety exercise, but that means that you're going to get cuffed, go to jail, and provide a sample.
So at that
provide
point,
a sample at the jail.
Yeah, basically refusing to the field sobriety test and
Right.
submitting yourself to be arrested.
Right. And there isn't any providing a breath test to get out of being arrested. That doesn't exist in Florida.
Okay.
So bottom line is if you find yourself sitting in front of an intoxilizer, you are arrested, and after you provide that sample, you're going to spend the night in jail, no matter what the sample is.
Wow.
So that kind of leads us into the next area, which is the breath test area. So the breath test aspect of a DUI is something that, again, that comes after you've been arrested, and a person is asked to provide a sample into a breath test instrument. And the breath test instrument they'll usually be sitting right in front of the instrument around this time, and the instrument can only be operated by breath test operators, people who are certified to actually use this instrument. So
And
it may not
done at the jail.
done at the jail. So it may not always be the officer who arrests you. Sometimes it is, sometimes it isn't.
Okay.
And if the person refuses to submit to the breath test, the officer is going to read that person what's called implied consent. Implied consent is a warning that basically has been provided by law to indicate to the person that if they refuse to submit to a breath test, their refusal could result in a suspension of their driver's license up to 6 months for first time. Up to a year for the first time suspension, and up to 18 months for a second refusal to submit to a breath test. So they have to read this person that implied consent. If they don't read them that implied consent, later on there's things that we can do to get that person their license back if the officer takes it. The other thing that's important to know is if a person has been arrested before for a DUI and they refused a breath test previously when they on a previous arrest, a refusal to submit to a breath test is actually a crime. It's actually something it's a first-degree misdemeanor that you can actually spend time in jail for if you refuse to submit to a second breath test. So these are all...
If you've had a previous DUI.
Correct.
Okay.
Absolutely correct. And again, they have to be informed. That person would have to be informed that a refusal to submit to a test, if they have a previous refusal, is a crime. They have to be informed of that as well. And those are things that sometimes you get to pick up. I get to evaluate when the person's being asked to submit to the breath test. A lot of times there's video of that, and I get to see the video. I get to see how the question was asked. I get to see if the officer asked everything he was supposed to ask. If the person agrees to submit to a breath test, they're going to provide 2 samples. And what it is you blow into this. It doesn't look like anything from the future. It looks like a little box sitting on a table, and it has this tube, and that has a detachable part, that they can replace for other people to blow into it. And you blow into this tube, and it's designed to get what they call deep lung air. So they want you to exhale into this instrument for a prolonged period of time until you blow all the air out. And you have to provide 2 breath samples. And the reason why you have to provide 2 breath samples is they want to make sure that the instrument doesn't have a wildly different result for the 2 blows. If you provide 2 samples, the samples must be within 0.02 of each other. If they're not within 0.02 of each other, the person has to provide an additional sample. Before you provide a breath test, the officer is supposed to be observing you for 20 minutes at least. He's supposed to observe you for 20 minutes to make sure you don't do things like burp, regurgitate, hiccup, things that might cause some deep lung air, something in like in the pit of your stomach, to come up, because that may have an impact on the accuracy of the result. They don't want mouth alcohol. Mouth alcohol could throw the instrument off. The instrument's supposed to be designed to detect for mouth alcohol, but they try to avoid any kind of problems by making sure you don't have any of these moments where you might For instance, if you burped, you're releasing things from your stomach, and it tends to go into your mouth, and it'll provide a different sample potentially than what your breath sample actually is.
And when do they do that, or how do they document
Well,
the 20
that's
minutes?
interesting. That's actually a subject of litigation sometimes
Okay.
for defense attorneys. So the officer documents when the 20-minute observation period begins, and the best time to do it, the most legitimate time to do it, I would say, is when the officer takes you back to the jail and he has you sitting kind of in front of him, and he's maybe going over some paperwork for the arrest or something like that. That would be the best time before you provide a sample. I have seen instances where officers try to consider the 20-minute observation period the period that the person is taken into custody, and he's sitting in the back of the patrol car as he's driving to the jail. There's the reason why I think that might be a problem is I'm sure officers are observant. I'm sure they're skilled in what they do. I don't believe you can have a very accurate observation of a person to see whether they burp, hiccup, or anything unusual prior to a breath test if they're sitting in the back of a police cruiser and you're sitting in the car driving it. I just don't think that provides a very adequate 20-minute observation period. I have seen lately that that they start to do it at the jail, but it used to be for a long time. I've seen them starting the observation period when the person was taken into custody, and that has caused a lot of cases to where you try to get the breath test results suppressed. You explain to the court that there's a certain procedure designed for these instruments that are finely tuned, and the process has to work a certain way in order for us to have any faith in the outcome of these results. And if the officers don't observe that 20-minute observation period, we'd ask the breath test to be suppressed. And of course, if you suppress the breath test, you might again inch further towards reasonable doubt.
So after the 8-hour holding period,
Yes.
that's when they'll allow a phone call, or that's when they'll allow you to leave.
Well, they'll allow a phone call if it depends on where you are.
Okay.
If you're actually in a jail cell, it might be more difficult. When they arrest you, every agency is a little bit different, but usually they have you kind of in a holding area, and there's usually one phone available, so you can kind of make a call when you can get to it, but it just depends on when you can get to the phone. But if it's a person's first time DUI in areas like Clearwater, Pasco County, Hillsborough County, or Hernando County, you might see a person released on his own recognizance for first time DUI, or maybe a bond of $250. And at that point, when they bond out, they really need to start thinking about what they're going to do about a lawyer. And the reason why is because in the state of Florida, you have 10 days. When you get arrested for a DUI, whether you refuse a breath test or you submit to a breath test and you blow above a .08, the officer will take your license from you. And when he takes your license from you, he issues you a DUI citation. And that DUI citation is good for 10 days to sort of get your affairs in order. And after that 10 days, your license is suspended. In the state of Florida, within that 10 days, if you either sign up for DUI school and go to the DMV within those 10 days and tell them that you'll waive any formal review hearing, which is an administrative hearing of your suspension, the DMV will issue you a hardship license, which will last you throughout the DUI case. Some people want to challenge the stop, and I think there are some circumstances where I think it's a good idea to actually have a hearing at the DMV. In that instance, you wouldn't waive the formal review hearing, but you say, I want a formal review hearing. I want to have an administrative hearing on whether or not you can take my license. The DMV taking your license is separate and apart from the criminal court suspending your license. Those are two different moments that happen at two different points in time. The DMV is administrative. They say, if you want to drive on our highways, you have to take our breath test. If you don't, we'll consider that a violation. We'll take your license. So you're entitled to challenge that. And I've had hearings at the DMV where we challenge whether or not the instrument was properly calibrated, and maybe the level that they say is not a level you can have any faith in. Or maybe they say the person was, advised of implied consent, but maybe he wasn't. And in those instances, the person, if you win the hearing, would get their full license back. It would be unfettered. There wouldn't be anything for work or business. It would be for whatever you want. You can drive. The downside to having a formal review hearing is if you elect to have that hearing at the DMV, if you lose, you you have to go through what's called a hard suspension period before you can get yourself a hardship license. So if there was a refusal, for instance, and we went to a formal review hearing and we tried to beat the suspension, but the facts were that we couldn't, and the DMV affirmed the suspension, the DMV would then say that the person could not drive for 90 days. And after that 90 days, if that person signed up for DUI school, he could get a hardship license. And if it's a breath test above a .08 and you lost that formal review hearing, the DMV would say that person cannot drive for any purpose whatsoever for 30 days. So in my experience, it's always been the best idea to waive the hearing because you get very little. You know, you could win the hearing, great. You have a license without restriction, but you could lose so much. I mean, there's a lot of folks who, if you told them they couldn't drive for 90 days whatsoever, they wouldn't know how to operate. They wouldn't know how to get to work.
They'd lose their jobs. Yeah.
Yeah.
So recommendation after you get out of jail is really pretty much immediately call an experienced criminal defense attorney like the partners there at Bauer, Crider, and Perry.
Absolutely. Absolutely.
Get that
we can
10 days process started.
Correct, because we can get you in contact with the DUI school that you need to get in contact with to sign up for it, and then we can get you in contact with where you need to go to get your license. And listen, doing DUI school isn't saying I'm guilty of the DUI. You know, that's unfortunately a requirement to get your license that the state of Florida has. I want everyone to know when they come in to hire a lawyer for DUI, it is not something where we say, how do we just roll over and get this thing done to where it doesn't hurt? We want to fight these things. And we always start off with an idea, how do we beat this? And obviously, as you look at the case and as you fight with the case and as you get experience with looking at it, the lawyer can give that person advice on what the best plan of action is. But it's always going to be in the very beginning, how do we get this thing beat?
So at Bauer, Crider, and Perry, somebody calls your firm. They've been arrested for a DUI. Do they speak to a paralegal, or do they actually talk to one of the attorneys?
It's been my obviously the paralegal is going to answer the phone, but it's been my experience that folks who go through this process who get arrested are scared. Their whole life is kind of spinning around a little bit, and they want to talk to somebody who can give them some comfort in knowing what there is to expect. So because of that, we have everyone talk to a lawyer. Sometimes they have to leave a message and the lawyer calls them back. But when you're talking about your case and giving information, you're talking to a lawyer.
And name the lawyers there at your firm real quick for me.
We have Robert Bauer. We have Ronnie Crider, Curtis Crider, David Perry, and then yours truly, Michael Kenny.
Mike Kenny. All right. Mike, anything else?
No, sir.
All right. Well, you've been listening to the Bauer, Crider, and Perry podcast. If you're in the Tampa area and you've been arrested for a DUI, contact the experienced criminal defense attorneys at Bauer, Crider, and Perry.
Thank you for listening to the FloridaDefense.com podcast. Our firm has over 130 years of combined legal defense experience. Strong defense, stronger results. Consultations are free. Visit FloridaDefense.com today.